How are you this evening? Oh, come on. Come on, we're all good?
Yeah.
All right. I imagine I'm going to do this in English. Nobody needs for me to translate in Spanish. Am I correct? All right, good.
And I don't know about this, but
This microphone in my hand really bothers me, but we'll do this for a little while. This is my last seminar for the year, and I thank you all for coming. Some of you know me, some of you have met me, I've met you before. You've dealt with Joe and the staff here. I want to give you, because today's seminar is going to talk about a lot of things, but the underlying message I want you to know is they're coming after you. They're coming after you. They don't want to pay you. And not only that, they want to put you out of business. Who are they? State Farm, Allstate, Mercury, Direct, all of them. All of them want to come after you. They're looking at all kinds of angles. One of them is the legislature. One of them is changing laws. The other one is saying fraud. But that word, it's been 30 years. I hear the word every day. I'm tired of it. Because it's a lot of bull. No doubt there is some. No doubt. There's fraud in everything. Fraud in Wall Street, fraud in Medicare, fraud in Medicaid. Everywhere. No doubt. But the levels that they bring it to, within the last month, today, there was a workshop in Tallahassee. Within the last month, coming to the workshop, there's been 36 articles written about how rampant fraud in the state of Florida is costing our poor people so much money in insurance. And what did that want to say? In this time, hold on, I got a quote. Jeff Atwater says, during these challenging economic times, oh my God, Florida families cannot afford to spend one more dime on increased insurance costs. It is my mission to stamp out auto insurance fraud and to ensure these cheats who are making money off the backs of Florida drivers serve real time. Oh my God. They're coming after you. When I was a younger man, I lived in New York and my daddy had a body shop, auto body shop. So we dealt with insurance all the time. And they would come in and say that car is worth $300 to fix when it was really worth $3,000. And when we got tough with them, they said, fraud! So I heard it when I was 16, I heard the word 17, 18, 19, 20, all through my youth, I heard the word. And so I became a lawyer with an inherent hatred for insurance companies. How do we fight this? Exactly that. Fight. You fight back. You take your pursuits to the maximum. You force them to play you. How do you fight them? You assert your rights, because we still have some, and a lot of them. How do you fight them? Who's those people? Who's those people that we, that company that we were just looking at?
SMI.
SMI.
Yeah. Don't get me about it.
Okay. These people are coming around and making investigations for insurance companies. They're the SIU. They're the independent SIU. They come from the National Insurance Bureau, which is owned by insurance companies. They're the ones that say that 8% of the claims are fraud. Okay, but they never back up that statistic. In Tallahassee, we fight for them. It says, well, give us the underlying statistics, the underlying information, the data. We have not got it for the last 10 years, because there is none. You fight. Today, PIP is said very generally, and we're going to go through a lot of specifics, But very, very generally, if you don't fight, you're not going to collect. They're not going to give it to you. They don't want to give it to you. What they're looking for is for people to pay premiums and not have to pay claims. Exactly what they've been looking for 30 years. As a matter of fact, so you know, that's the... Who was here when PIP started? Anybody? Anybody in this room was here when PIP started in 1972? Nobody? Do you know why PIP is PIP? Do you know who were the ones behind PIP? Who were the ones that convinced the legislature to make no-fault insurance? Exactly. You know why? Tell you why. Because the third-party claims were all $20,000 on whiplash cases. They were getting killed. What happened? They said, well, let's pay them 10 and put a threshold. In the PIP statute, we have that thing that's called permanency. Prior to PIP, nobody had to give a permanency rating. Prior to PIP, I could be cured of my whiplash and get paid for pain and suffering for the 3, 4, 5 months. Now, no. Now I need to prove permanence. And as you know, your BI cases, what, 2,000, 3,000, 4,000? Don't go too much more than that when you have a whiplash case. So it was them trying not to pay. But they did their typical. Once they got their 10, and once they got the law, then they said, 10 is too much. Let's cut. And then they got sued. And that's what's happening. Come on, they got a Medicare fee schedule and they still take cuts. And they still do line reviews. And they still do peer reviews. What do you think? The whole basis is I don't want to pay. And if you don't fight, you're not going to get paid. That's the first thing. Number 2, if you don't assert your rights. You got anybody from an insurance company in your office, you call the cops and get them out. Guys, cooperating with insurance companies is like leaving your kid with Sandusky in the shower. I'm sorry I had to do that. But that's what it is. They're not there to help you. SIU investigators aren't there to help you. Insurance adjusters are not there to help you. They do not get paid money for giving you money. They get paid incentives for not giving you money. They're there to find a way not to pay you. They're there to find a way to intimidate you. They're there to find a way to try and find an excuse for not paying. That's what they're paid for. Why? Why? Don't allow them in. You don't have to. In fact, they can't really do it. They can only come in and ask for the original file so that they can look at it. That's all they can do. You don't have to ask questions. You don't have to take the third degree. Nothing. No. That SMI company, that's the one that comes in looking for you to withdraw that PIP claim. And that's not the right way to do it. They're not there for you. Talking with insurance companies will only, it's sort of like you're charged with a crime, and they are charging you with a crime. The moment an SIU investigator walks into your office, you are not getting paid. You are not getting paid already. He just wants to catch you now. Do you understand? It's like getting arrested. Same thing. Don't say anything. He's not going to let you go. As soon as the cop arrests you, you will not convince him to let you go. You will not convince the SIU adjuster or investigator to pay you. You will not. There's no way. He's going to listen. Not to your good story. No. So don't. I have offered that you just call my office. We'll talk to him. You watch how quickly he leaves. You watch how quickly these investigators leave. Once you put our office on the phone and says, my lawyer wants to talk to you. I'm not saying anything until my lawyer tells me I can't. They give up. They give up. And I'll tell you what, they know who we are. Yesterday, this was in Dade, but in Dade County, one of my clients in Dade, just like you guys, calls me and says, there's this Carlos Duque here, and the moment I dialed your number and I says, I'm going to call you, he laughed. Neil Gonzalez is unreasonable. But the only reasonableness he wanted is for my client to withdraw the claim. That's the only thing that they think that was reasonable. Do you understand? That's the only thing they're looking for. They're not negotiating. They're not saying, okay, I'll tell you what, I'll pay you half. No! They want you to withdraw the claim. That is the introduction, because basically, you don't fight, you can't collect. And they've got little files on you guys. They know who you are. They know how you practice. They know how you are everything. And if you think that each insurance company doesn't talk to each other, you're absolutely wrong. Because I'll tell you what, the lawyers that represent State Farm also represent Progressive, also represent Mercury, so when they find something out, like you do not fight your cases, you don't want to go to depositions, State Farm knows, Progressive knows, Direct knows, Mercury knows, Allstate knows. And they meet with each other. All those little hoodlums get together all the time. Okay? They all get together and they talk about this. Just like us plaintiffs lawyers get together and talk about stuff. Same thing. The other thing, the third thing, and that's what we're getting at, and this will be the gist, the brunt of this, is during the claims process, this has become very technical. Papers become technical. During the claims process, you need to make sure you do the right things so you can get paid. So you can't give them that reason. So you make any denial, all right, be unreasonable on their part. So that when I get involved, if I have to, they got to take a real good look at this and say, are we willing to pay fees also? Are we willing to pay fees? Do we have something, do we have enough that we have a possibility of winning? And that's what I don't want you guys to give me at the claims level, the possibility. I want that the cases that you guys bring me are all about IME superiors. Not about mistakes that you made. Not about that. Some of these technical mistakes, we can't get around. First one. Incorrect response to the insurance company's 6B request. Okay, most of you should know that Joe and my staff here are all willing to respond for them, to do them for you, and to train you how to do them by yourself. But not responding, we can't get around that. Let me explain. When you receive a 6B request, and the letter must say 6B request, if that trip stops the 30 days, it stops it, freezes it right there. When you respond, and they receive that response, they now have 10 days to pay you. Starts up the clock again, but it only provides them 10 days. If you do not respond, the clock stays stopped. You give me the file, I send the demand letter, and the response is, demand letter is premature. Why? Because there's a 6B request, these bills are not due. I don't have to pay it, I'm not due. I'm not overdue. No. And so now I have to provide a 6B request and a response. And some of your files don't even have the letter. I don't know what you guys do with it. Sometimes we can throw it away or something. That's a very important letter, because that stops the toll. And in that, there are things that they can ask you for. And if you follow along with me, you'll see that they could ask you for a written report of the history, which is like something that you do anyway. The condition, the treatment that you provide the patient. You do that anyway. That's in your medical reports. The dates of service, they're on your soap notes or your treatment sheets. The cost of the treatment, you've billed it. Yeah, I know. Hey, I sent all this before. They already got this. Yeah, I know. So you respond saying, hey, insurance company, this is my response to your 6B request. You already have this. But that is a response. The statute doesn't provide for how you have to respond. It just says you have to respond. There's also, if you're going to send these records again, you can charge them $1 a page. Send them a little invoice. Pay me. Or, what I like most is, I've got all these for you, I sent them to you before, but until you pay me $1 a page, it's 100 pages. Once you pay me the $1 a page, the $100, I will send them to you. You've responded. They have 10 days. You have responded. Do you understand? And so, because I don't trust your insurance company, first send me the $100 and then I'll send it to you. You have responded. And now they have 10 days to pay. There's a sworn statement that must be provided also. It's in your, right, a sample is in your papers that I give you. And it reads like this, the doctor signs a sworn statement saying, I have read the medical reports, notes, and billings, submitted for all dates of service between such and such a date, they rendered to patient. I declare that all treatment of services rendered were reasonable, necessary, and related. It's real simple. All right? It's a real simple sworn statement that needs to be provided with 6B requests. That's it. What is not allowed? Because these 6B requests get really, really elaborate. They want proof of ownership. No, statute doesn't allow them to get that. They want personal information of the employees of the clinic. I saw one that wanted copies of all the timesheets and all the time cards of the clinic. Agreement or referral structure between partners. No need. Lease equipment, any advertising, any other requests outside. Simply on those requests you say, you're not entitled. The statute doesn't entitle you. That's it, that's a response. If they want to stand and say it was an inadequate response, they have no basis. Because the statute does not provide for adequate or inadequate. It just says response. They have to prove inadequate. Well, he didn't send me the medical bills. Well, but in number 2, you asked for the medical bills, it says you previously provided. Didn't they send them to you before? Well, yeah, you know why we know? Because the 6B comes after they receive the bills. So we know they received them. But why would we leave it without doing anything? My office is open. You receive one, you call my office, they'll help you do it. It's real simple. All you gotta do is call my number. They'll help you do it. And Joe, how much do you charge for that?
Comes with the business.
Okay. We don't charge at all. Comes to help you, my client. Gotta help you out. I'm not here to have every case sent to me. I don't want that, because you know what? If you do 30 cases this month, 10 or 20, whatever, and all of them don't get paid next month, I'm gonna lose you as a client. Why? Because you can't, you need cash flow to pay the employees, pay the rent, pay the electricity, pay for, if you have equipment that you've leased, you need money to continue. We all do, that's part of business. So I don't want all your cases, I want you to get paid. Again, the cases I want from you are IME cutoffs and peer reviews. Why? I'll beat them all the time. 9 out of 10. Because that's about these, please excuse my language, whore doctors that they get. They'll say whatever they want. And when we find out, I show to the jury that they're making $1 million a year doing this, okay? Jury will understand where we stand. They will. I told you they're coming after. This is something that was in business, was in the making for a long time. These declaratory actions. There's a few that they do. Basically, it's a material misrepresentation case. It's the insurance company filing suit against you and against the insured, not looking for money. They're not looking for money from you or the insured. What they're looking for is for a court to determine that there has been a material misrepresentation by the insured, and therefore they are not liable to pay. Basically, that's what there is. There's variations because sometimes they make a payment to you, okay? They make the first billing, they made a payment, and they're looking for that money back. That's in rare instances that they do, and then they, quote unquote, discover the alleged misrepresentation, and they want you to give them back the money. But again, basically they do this before they even pay. These, bring them right away. Bring them right away. Material misrepresentation is a very technical thing. It can only happen at one moment in time. And the moment in time is the moment the insured signs the application. It cannot happen at the accident. It cannot happen 3 minutes after. Give you an example. I go buy insurance. I fill out an application. I'm a single dad, but my daughter, who's 17, lives with her mother. So I'm all alone in my apartment. I buy insurance, I sign it. I come home and I find my daughter with all her bags and all her clothes saying, "Daddy, I'm moving in with you because I had a fight with Mom." Did I commit a material misrepresentation because now she's living with me? No. Because when I signed, she wasn't living with me. And in Florida, I do not have a duty. I do not have a duty to call the insurance company and tell them, hey, my daughter is now living with me. I don't. It can only happen that moment that I signed. So, very many times, okay, they will tell you that the person or the kid lived with the parents at the time of the accident. But that's understandable. But this also comes from a second thing, is EUOs. Okay? From unprepared patients going to the EUOs and not knowing what to answer and not knowing what to say. Second, if in fact one of the patients is the kid, that's an example, but they don't have to pay that one, but they do have to pay the insured, me. Why? Because that's the risk they contracted. Material misrepresentation is on the basis of, I contracted with you for a certain risk, you, and the people you put on the application. Now I find out that actually I have a bigger risk, I have more people. You were false to me. This contract shouldn't exist. Well, yeah, to the other people. But you did contract for me. Nothing's changed with that. And there is certain movement in that way towards this. Okay, this is a new strategy from Wynn Haven. It's the only one I've seen so far doing it, but I'm sure Charles Grimsley will sell his soul to the devil and other insurance companies. Let me explain who Charles Grimsley is. He used to be the general counsel of my one and favorite United Automobile Insurance Company. Since I can remember, I did not know United Automobile without Charles Grimsley there. He was the number 2 in command. Mr. Pepe? Mr. Perillo. Mr. Perillo, by everybody calls, I don't know, do you guys know who United Automobile is? I know you're up here and they don't sell it here. Okay, United Automobile is the insurance company that made the phrase, deny, delay, don't pay. Very famous. Mr. Perillo, a Chicago native, would run around. He wears a lot of shorts and sandals at the office of United Auto. He's a very wealthy millionaire. In fact, he has just finished building the most expensive home in the city of Chicago. It cost him $66 million to build. Anyway, he would run up and down the hallways yelling out, deny, delay, don't pay. Deny, delay, don't pay. That was his mantra. And so Mr. Perillo is called Mr. P by all his lovely minions, lawyers, adjusters, Mr. P. I call him to his face Mr. P. I don't like the man. Anyway, Charles Grimsley was his right-hand man for all these years. He fired him. And Charles Grimsley now has gone to insurance companies like Wynn Haven and said, there's fraud going on. No, these aren't fake accidents. It's not his fraud is based on this. You're not collecting the deductible. Therefore, what you're doing is you're overbilling so you can cover the deductible, and it's fraud. That's his basis. How do you resolve this? Because, guys and gals, you're going to see this again. You're going to see this by other insurance companies. This is another way of coming at you. 10-11 collecting. The statute says that you have to make a reasonable basis, a reasonable effort to collect the deductible. 10-11, put it in your file. 10-11, put it in your file. 10-3, put it in your file. For every billing to the patient. When somebody says you didn't collect it, I tried. Well, why didn't you get a collection agency and a lawyer? Tell you what, because I wasn't going to throw good money after bad. I'm not going to spend $2,000 to go get $1,000 with the lawyer. Right? In fact, insurance company, tell you what, take the deductible from what you owe. You owe me 10 grand. Pay me. Okay, we'll go houses. Don't be stupid. Don't be stupid, insurance company. This is something that is a complaint for damages because a lot of these have been paid. People have been paid, so they're looking to get back the money that they paid, plus interest, okay? And they're looking for one more thing. They're looking for damages and sanctions because you defrauded them, and therefore you should be sanctioned. I have, in Dade County, I have 5 of these. There's got to be about 400 right now ongoing because all the PIP lawyers have gotten together and we realized that he's filed them and we're all working together on this, but because we don't like Grimsley either. And we want to stop him so that he can't sell his services anymore. Wynn Haven is an insurance company that was looking to save money, and this guy sold himself as the guru of this. EUOs. I want to clarify, I think I came in front of you last year. Custer was last year, right?
2010.
Yeah, 2010. I came in front of you and I said we want a big one, which was Custer. Okay? But I think people misunderstood what I said. Before Custer, the law of the land in Pitt, erroneously, but that's the way the courts held it, was if a person didn't go to the EUO, all of it, you couldn't collect 1 penny, nothing. When we got into court, all they had to prove was that they notified the person properly, that I set the EUO within the 30 days of the billing period, and that the person didn't go. That's all they had to prove. And we lost. That's it. The only defenses I had was, whoa, wait a minute, that notice was improper. You sent it to the wrong address. Okay? Or you set the EUO outside of the 30 days, and pursuant to an old case called Amador, can't do it. I would win some of those, but they were getting very, very good at providing it perfectly. I began to make I'm not going to take credit to be the one that fucked this up, because I was taught by Mr. Carlos Lidsky to look at this and say, wait a minute. You're acting like that's a condition precedent. In other words, the EUO has to happen before I provide coverage. Precedent has to happen first before my duty is triggered. So this has to do first. It's sort of like, I'm going to build a wall for you. Well, our contract says that before I have to pay you, the wall must be built. Until the wall is built, my obligation to pay does not happen. That's a condition precedent. Okay? I said, well, we have a lot of cases with conditions preceding, where there's cases where State Farm tried to say, we're not paying it because they didn't give us a PIP application. And that case said, no, you can't. It's not in the statute. It doesn't say that you need a PIP application. Continuously, there's been cases like that, saying it's not in the statute. You can't use it as a condition preceding. My argument was, EUO is not in the statute. You can't use it as a condition preceding. I was getting beat. I was winning. I was getting beat because some judges say, hey, we've had 30 years of this law, we're not going to change. I'm not going to be the one to change. I'm not going to go against it. Some of them were brave and said, yeah, you're right. And finally, Custer says, Neil, you're right. It is a condition subsequent. In other words, I have the right to take that EUO. I have to notice it. I have to do it within the 30 days. And if the person doesn't come, I have to prove that I was prejudiced. That failure to attend prejudiced my investigation. One more little proof that becomes gigantic. How did they do that? Well, I don't know about the accident. Did you get the police report? Yeah, so you know about the accident. Well, I don't know about the treatment. Did you get the treatment sheets? Yeah, so you know about the treatment. Well, I don't know about the billing. Did you keep the hit first? Yeah, well, so you know about the hit. What was prejudice? Well, I don't know if they really gave him that treatment. And the EUO was going to give you that? You mean the insurer was going to sit there and say, I never got any other treatment? Really? No, okay. Did you call the clinic? No? Did you call them by phone? The insurer? You got his phone number? Yeah. Why didn't you call him and ask him? No? You weren't prejudiced. Very hard for them to prove. But that doesn't mean that your patient doesn't have to go. If they don't go, you're not going to get paid. Not at the clinic. because they're going to try to prove prejudice. And they're also trying to get around the language, and they're trying to they're still trying to see, but that's a Supreme Court case. They don't have very much to go. And all their rehearings have been denied, everything is denied. But it doesn't mean he doesn't have to go. What does that mean? That means that you need a patient, okay, that knows how to answer questions. One time in my life I got injured, and I went to an EUO. And they asked me, did you get electrical muscle stimulation? And I said, how does that feel? And they said, why? I said, because I don't know. Because I was laying on a table on my stomach with my head in a hole, and every once in a while they would put a newspaper or magazine so I could read something. So I don't know what they did, but I can't tell you how it feels. I don't know what they did. I wasn't looking. As a matter of fact, some of the stuff felt so good I fell asleep. Therapist would wake me up and say, come on, you finished. Yeah, I'm ready. Can I get a little more, please? It was good. People, your patients going to the EUOs are going to get intimidated big time. I have a case where the person goes into the EUO, and the lawyer starts the EUO, and the court reporter stops and tells the court reporter to go out and begins to call that person a crook, a fraud, all names you want to hear, but it's off the record. Then he calls back the person and he continues the interrogation, sends him out again, and intimidates. We're going to put you in jail because I know I got proof. I have proof. You know what? That therapist in the clinic said that nothing happened, and you're lying to me right now. Did you get this treatment? Send the person out. But if you withdraw your claim right now, we'll forget all about it. What does this mean? It means we need patients to go there either represented, because they can't do that if a lawyer is there. No way. Or well-trained. Because the first thing that you train them is, if that court reporter is not writing what is said, you don't say anything. In fact, if the court reporter leaves the room, you leave it too. And you wait outside until it's time to come back in. Because that's what I would do. First of all, they wouldn't do it if the lawyer is present. Okay? But when the court reporter leaves, let's say she's got to go to the bathroom, or she's got to go get water or something, and everybody stops talking. I don't even ask the lawyer how his kids are. I don't really care. Also, when they ask him, what treatments did you get? Why aren't your therapists saying, and now I'm going to give you electrical muscle stimulation, and now I'm going to do ultrasound, and now I'm going to do manual massage, and now I'm going to do exercises, cause. Did you do exercises? What do you mean? Yeah, exercises. They do exercises. No, because the person don't know that he was turning that wheel as an exercise. The person doesn't know that. Exercise means push-ups, sit-ups. That's what it means to these people. Ultrasound, they do ultrasound. No, I'm not pregnant. I gotta be honest with you guys, when I got into this business, when I saw ultrasound, I really thought that. I didn't know it was therapeutic ultrasound. I thought ultrasound was find a baby and find out if he's a boy or a girl. That's what your patient is thinking. That's what they're thinking. Don't think they know. They don't know anything. And they're getting intimidated. They're going to get nervous. They're going to really, really be scared at moments. So, for that, again, I have offered that if you guys want we will represent. It's gotta be paid, I can't do that for free. Right, because it usually takes 2 hours, 3 hours, stuff like that, that we will represent. At the very least, we will be on a phone, not with the patient there, not all the time, but via phone, and we can stop it and tell the patient, get up, walk out. Okay? All you gotta do is we will do it for you. How many have received withdrawals of claims from insurance companies saying, we took an EUL with a patient who withdrew their claim, and now we gotta fight? That's what they're doing. They're coming after you. In all they have done, they're doing a concerted effort. Every way possible, they're trying to get away without paying. On each claim, in Tallahassee with the law, everywhere, they're coming at you. This is your livelihood, this is my livelihood. I'm not allowing that. I'm fighting.